Hello everyone, this is lecture 5 on the Supreme Court Rules 2013. We are going through order 4 of part 2. In the first video, we had discussed rules 1, 2, 3 and 4. This is second part of the same video. We will be discussing rules 5 to 23. Let's begin. What is rule 5? Rule 5 in short is sine qua non for qualification as an advocate on record. It has 4 subclauses. Let's see what is first subclause. No advocate shall be qualified to be registered as an advocate on record unless, first, his name is and has been borne on the roll of any state bar council for a period of not less than 4 years on the date of commencement of his training as provided hereinafter. So I should have completed 4 years of registration on the date from which I am beginning my training with an AOR. There is a proviso attached to it. It says, provided, however, if any candidate has earlier appeared in any of the advocates on record examination, he shall continue to be so eligible to sit in any subsequent examination. Have you already appeared and you did not qualify? Alright, your eligibility continues. You don't have to go through training again. Let's come to second subclause. No advocate shall be qualified to be registered as an advocate on record unless he has undergone training for 1 year with an advocate on record approved by the court and has thereafter passed such tests as may be held by the court for advocates who apply to be registered as advocates on record. Particulars whereof shall be notified in the official gazette from time to time. Provided, however, that now a proviso is attached to it. Let's see. What is sub-rule 2? First tell me this. So, I will have to go for a 1 year training with an AOR. Then I will have to pass the test. Proviso is basically it exempts certain advocates from training and tests. Let's see what does it provide for. Clause A of the second subclause. An attorney shall be exempted from such training and test. So if I am an attorney, I will be exempted from training as well as test. B. A solicitor on the rolls of Bombay Incorporated Law Society shall be exempted from such training and test if his or her name is and has been borne on the roll of the State Bar Council for a period of not less than 7 years on the date of making the application for registration as an advocate on record. So if I am an attorney, there is no time limit fixed that you will have to go for 7 years or 10 years. I will be exempted from training and test both. What if I am a solicitor on the rolls of Bombay Incorporated Law Society? Then too, I am exempted from training and test. But there is a condition appended to it. The condition is that on the date on which I am making the application for registration as an AOR, 7 years must have passed since I have been enrolled on my state's bar council. Alright, now what is subclause C? Now this is the power of the Chief Justice. The Chief Justice may grant exemption. Subclause 1 provides, the Chief Justice may, in appropriate cases, grant exemption from the requirement of training under this clause in the case of an advocate whose name is borne on the roll of any state bar council and has been borne on such roll for a period of not less than 10 years. So I'm an advocate and I'm having experience, I'm having seniority of 10 years. My registration, I have completed 10 years of my registration. So Chief Justice has power. He may grant me exemption. But see, exemption from what? Exemption from test? No. Exemption from training only. Now let's come to second subclause. The Chief Justice may in appropriate cases grant exemption, clause 2, from the requirement of clause 1 and from training under this clause in the case of an advocate having a special knowledge or experience in law. So again, the Chief Justice has power to exempt these two lawyers. Exempt from what? Not from test, only from training. Subclause 1 provides, if I am an advocate who has completed 10 years of practice, the Chief Justice may grant me exemption from training. Or if second subclause says, if I am an advocate who is having special knowledge and experience in law, I may also be granted exemption from training as well as subclause 1 of Rule 5. Now let's see what is sub-rule 3. It provides that I, as an advocate, if I have to give the advocate on record examination and I have to further qualify as an advocate on record, then I will have to show that I have an office in Delhi within a radius of 16 kilometers from the courthouse. And I will have to give an additional undertaking that I will employ within 1 month of being registered as an advocate on record, a registered clerk. What is subclause 4? If I have to qualify as an advocate on record, I will have to pay a registration fee of 250 rupees. Now let's see what is rule 6. Rule 6 in one word is ineligibility. It comprises of two sub-rules. Sub-rule 1, I am an advocate. I have been convicted. Will I be able to work as an advocate on record? Will I be registered as an advocate on record? No, I will not be. Let's see what it says. An advocate who has been convicted of an offense involving moral turpitude, naitik patan, shall not be eligible unless the said conviction has been stayed or suspended by any court to appear in the tests referred to in clause 2 of rule 5 on and from the date of such conviction, and thereafter for a period of 2 years with effect from the date he has served out the sentence or has paid the fine imposed on him or has served out the sentence and paid the fine imposed on him, as the case may be. There is a proviso attended to it. Proviso says, provided that the Chief Justice may, if he thinks fit so to do, relax the provision of this rule in any particular case or cases. We don't need to go through so much of detail. We will only read that I am an advocate, I have been convicted. Convicted of what? Murder? No, moral turpitude. I have been convicted of moral turpitude, naitik patan. I will be debarred. I cannot give my examination. I am not eligible. Well, can the Chief Justice allow me? Chief Justice may relax this provision in my favor? Yes, he can. There's a proviso. Proviso empowers the Chief Justice. What is sub-rule 2? Now let's see. Nothing in clause 1 shall apply to an advocate who has been released on probation of good conduct or after due admonition, and no penalty has been imposed thereafter in the manner provided under the provisions of the Probation of Offenders Act 1958 or under section 360 of the CRPC. So in short, just read that rule 1 will not be applicable if I, as an advocate who was convicted for moral turpitude, I have been released on probation of good conduct or after due admonition and no penalty has been imposed on me. Then sub-rule 1 will not apply. Let's come to the second part now. This is rule 7. Rule 7 is entitlement of an AOR. What is sub-rule A of rule 7? An advocate on record shall, on his filing a memorandum of appearance on behalf of a party, accompanied by a wakalatnama duly executed by the party, be entitled, first, to act as well as to plead for the party in the matter and to conduct and prosecute before the court all proceedings that may be taken in respect of the said matter or any application connected with the same or any degree or order passed therein, including proceedings in taxation and applications for review. Second, to deposit and receive money on behalf of the said party. Sub-rule B. What is it? It is certify plus endorsement. Where the wakalatnama is executed in presence of the advocate on record, he shall certify that it was executed in his presence. Sub-rule 2. Where the advocate on record merely accepts the wakalatnama, which is already duly executed in presence of a notary or an advocate, he shall make an endorsement thereon that he has satisfied himself about the due execution of the wakalatnama. Rule C. No advocate other than an advocate on record shall be entitled to file an appearance or act for a party in the court. Sub-rule D. Every advocate on record shall keep such books of account as may be necessary to show and distinguish in connection with his practice as an advocate on record. What will it provide for? Firstly, money is received from or an account of, and the money is paid to or an account of each of his clients. And second, the money received and the money is paid on his own account. Then what is sub-rule E? Every advocate on record shall, before taxation of the bill of costs, file with the taxing officer a certificate showing the amount of fee paid to him or agreed to be paid to him by his client. So these are, in short, these are entitlements of AOR. So Rule 7 is entitlement of AOR. Sub-rule A of Rule 7 provides that there has to be a memo of appearance and wakalatnama. Sub-rule B provides that AOR has to certify and has to endorse. Sub-rule C provides that only AOR is entitled to file an appearance or act for a party in court. Sub-rule D provides that AOR has to keep books of account in connection to his practice. Means fees and all, everything he will have to disclose. And E, he will have to file a certificate related to taxation. Now let's see what is Rule 8. Rule 8 provides that as an AOR, if I have ceased to have an office or a registered clerk as provided earlier, then I will have to face consequences. What is Rule 9? Rule 9 is if AOR has been suspended from the State Bar Council rule, it will be deemed suspension from the role of advocates on record. What is Rule 10? Rule 10 provides that if AOR is guilty of misconduct, a permanent or temporary removal order can be passed. There is a proviso attached to it. Proviso provides that principles of natural justice or de altrum partem has to be provided to the AOR. Misconduct and conduct unbecoming of AOR has been explained in Rule 10. What is Rule 11? AOR can request the registrar to remove his name. I don't want to be AOR anymore. Alright, I will place a request to the registrar and ask him to remove my name from the roll of advocates on record. What is Rule 12? It provides that AOR will notify the changes to the registrar. What changes? Changes of his or her email address, address of his office in Delhi, and every change of such address and any notice, writ, summons or other documents sent on such email address or served on him or his clerk at the address so notified by him shall be deemed to have been properly served. And what is Rule 13? In short, it is about clerks of the AOR. We need not go through it. What is Rule 14? Well, Rule 14 is list of touts. The registrar shall publish list of persons proved to his satisfaction by evidence of general repute or otherwise, habitually to act as touts to be known as list of touts, and may from time to time alter and amend such list. A copy of every list of touts shall be displayed on the notice board of the court. Then there is an explanation appended to it. It explains the tout, who is a tout, and other things are explained in that. We need not go in that depth. What is Rule 15? No new AOR without consent from the earlier AOR or by the leave of the judge in chambers. You cannot get a new AOR. You want a new AOR? Get consent from your earlier AOR. You are not getting consent from the earlier AOR? Go and request before the chamber judge. When these conditions will not be required, if the AOR has died or has become unable. What is Rule 16? Rule 16 is where a party changes his advocate on record. The new advocate on record shall give notice of the change to all other parties appearing. Party has changed its AOR. It will notice this fact to all the parties. What is Rule 17? No advocate on record may, without the leave of the court, withdraw from the conduct of any case by reason only of the non-payment of fees by his client. I'm an AOR. I'm going to withdraw from the case. Why? I have not been paid the fees. No, this is no ground. This is no ground. Rule 18. Rule 18 provides, again, duty of the AOR. I'm an AOR. I have been designated as senior advocate or judge. Now what? An advocate on record who, on being designated as a senior advocate or on being appointed as a judge or for any other reason ceases to be an advocate on record for any party in a case shall forthwith inform the party concerned that he has ceased to represent the said party as an advocate on record in the case. What is Rule 19? No in-person hearing if represented by the AOR. No person having an advocate on record shall be heard in person save by special leave of the court. What is Rule 20? No advocate on record shall authorize any person whatsoever except another advocate on record to act for him in any case. Rule 21. Every advocate on record shall be personally liable to the court for the due payment of all fees and charges payable to the court. Rule 22 provides for partnership between two or more AORs. And Rule 23 provides for partnership between two or more advocates not being AOR or senior advocate. So this is it. Order 4 has finished. Now very soon we will upload a video on Order 5. It is something very important. It provides for business and chambers. So this, as an advocate practicing at the Supreme Court, we are required to understand. Thank you for watching the video. If you really like it, please do subscribe and share.